Am I audible, visible? Can someone confirm? Check, check, check. Hello, 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 hello. Can somebody confirm? Good evening, guys. Can somebody confirm? Audible, visible? Check, check, check. Hello. Hi, Jirag. Hi, Steffi. Hi, Tesh. Hi, Chandana. Hi, Uday. Hi, Venkatesh. Hi, Sushmita. Can somebody confirm whether audible, visible so that we can start? Great. So, good evening, everybody. Welcome to the class. And we were doing logger revision. Yesterday, we have completed preliminary. Okay, before we proceed, as usual, we have a habit of playing KBC. So, we'll be doing KBC first, then we proceed with the further part. Okay, now, can somebody tell me small company? Small company is not is a dash type of company, can never be a small company. Dash type of company can never be a small company. Dash type of company can never be a small company. Please write in the chat. All those people who have come live, great. Dash type of company can never be a small company. Dormant, OPC, small, sorry, Section 8 and startup private company. Ha 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 ha. Mistake. Mistake, 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 mistake. Mistake, 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 mistake. Number one, small company has to be a private company and holding subsidiary, Section 8 and special act company. Hus, hus, hus. HSSS, hus, hus. DOS wala answer is for cash flow. Cash flow is not applicable to DOS. So a lot of people have gone wrong here. I hope in the exam you don't go wrong. Okay, it is holding subsidiary, Section 8 and special act wala company can never be a small company. Okay, remember this. Now when I talk about associate company, how much percentage I have to check? Associate company, how much percentage I have to check, guys? Venkatesh, you are also wrong there. Come on. How much percentage do we check for associate company? It is minimum 20%. Minimum 20%. Okay. When I talk about holding and subsidiary, holding and subsidiary. Holding and subsidiary के लिए what is the percentage given there? Holding and subsidiary का percentage, guys. Holding and subsidiary. Viresh 0, Jayant 0, Rishi 0, Nazia 0, Anusha 0, PK 0, Tarun 0, Shiva Kumar 0, Sai Prasad 0, Raji 0. The answer is more than 50, more than 50, more than 50%, more than 50%. So many times I have recalled in the class. Yesterday also we have done the class. Still you people are not remembering. Hitesh 0. It's more than 50%. More than 50%. At what percentage do we become government company? At what percentage, guys, do we become government company? Please answer in the chat. What percentage do we become a government company? More than 50% is not 50, and it is more than 50, 50.01 also is 50, more than 50. PK, please don't use your not so common sense. Nonsense. What percentage do we become government company? Tarun CS wrong. minimum 51%, at least 51%, not less than 51%. Thank God, at least this much you know. To declare interim dividend, which resolution do we require? To declare interim dividend, which resolution do we require? Please write in the chat. Sushmadar, wrong. Tell me. Bhumi, you are wrong. Board resolution, board resolution, board resolution. Okay. Now, in case if I am declaring interim dividend and I have a loss, so it says my rate of dividend should be dash of average rate of last 3 years. What is that dash? My rate of dividend should be dash of average rate of last 3 years. What is that dash? Bhumi, please check. You are wrong there. It has to be board resolution. Quickly. What is that dash? Sushmita Harsha, 0. Lakshman, 0. Less than or equal to, less than or equal to average rate of last 3 years. My rate of dividend should be less than or equal to average rate of last 3 years. Okay. Now, when we talk about dividend, section number is 127. You have to, once you have declared, you have to pay within 30 days. If you have not paid, how much is the interest on the company? Don't go wrong here. Okay. Don't go wrong. How much is the rate of interest there for penalty? How much is the penalty on the company? Don't go wrong here. Okay. Very good. 18% simple interest per annum, 18% simple interest per annum, 18% simple interest per annum, and directors 1000 rupees per day, maximum 2 years ka imprisonment. 1000 rupees per day, maximum 2 years ka imprisonment. Section number was 127. Okay. So we have done 123, we have done 127. We have also done 126 also. Abeyance also we have done. I hope you are getting confidence, people. I am purposefully saying your name. If your answer is wrong, don't take it in the other way. Don't take it in negative sense. See, once I'm telling your name, your answer is wrong, so that you make a, if you're making a mistake here, you will not make the same mistake in the exam. Okay. People who are giving right, I'm not telling their name because it is right. People purposefully, I'm saying your name so that you feel that was my answers are going wrong here, so I need to work more harder so that I don't go wrong in the exam. Okay. That's the only logic what I'm using here. Okay. Cool. Now, we talk about 124 and 125. We talk about 124 and 125 now. Very simple it is. So, dividend is declared. Dividend is declared within 30 days. Okay. So, dividend is declared at the AGM. It should be paid. It should be paid or it should be claimed within 30 days. That means it should be transferred to shareholder account within 30 days. Now, if it is not claimed, if it is not claimed, you will transfer it to unpaid or unclaimed dividend account. Okay. It would be transferred to unclaimed or unclaimed dividend, unpaid or unclaimed dividend account in a scheduled bank within 7 days. Okay. In a scheduled bank within 7 days. So to go to unpaid dividend account, it is 7 days. There. The money will be staying. The money will be staying for how many years? 7 years. The money would be staying for how many years, guys? 7 years. The money would be staying for how many years, guys? The money would be staying for, oops, sorry. Slide is not working. Hold on. Sorry, my mistake. So I hope you guys remember the content of preliminary chapter and dividend ka half chapter. Today we will finish off the dividend. We start with deposits today. Okay. Now see. So we were left with, we have done 123, that sources of dividend. We have done 126 abeyance. We have done 127 time limit. We are just left with two section 124 and 125. Now it says, see, dividend once declared, it should be paid, it should be claimed, it should be paid, it should be claimed within 30 days. That means the money should go to shareholder ka bank account. If it is not claimed or if it is not paid, okay, it will be transferred to unpaid or unclaimed dividend account. If within 30 days, if he has not claimed, the money will be transferred to a separate bank account in a scheduled bank, which is called as unpaid or unclaimed dividend account. To go to unpaid dividend account, the days are how many days? 7 days. The days are how many days? The days are 7 days. The money will be staying there for how many years, guys? 7 years. The money there will be staying for how many years, guys? 7 years. Sir, can the investor claim the amount? The answer is yes. Investor can claim the amount. He has to go to the bank and claim the amount. So if the investor have not claimed the account, claim the amount. If the investor has not claimed the amount, so you will transfer the amount. You will transfer the amount along with the shares to IEPF. You will transfer the amount along with the shares to IEPF. IEPF means Investor Education Protection Fund Authority. Sir, if the money has gone to IEPF, can the investor claim? The answer is yes. So if the shares have gone to IEPF, can the investor claim? The answer is yes. After transfer, the shareholders can reclaim the shares and also the dividend. To claim, you have to apply to whom? You have to apply to IEPFA. To claim, you have to apply to whom? IEPFA. So what is IEPFA? Investor Education Protection Fund Authority. Investor Education Protection Fund Authority. Understood this much? So, sir, the duty is of the company to transfer the money to unpaid dividend account within 7 days. Sir, if you have transfer on 10th day. So that means day 8 ka delay is there, day 9 ka delay is there, day 10 ka delay. So 3 day ka delay is there. Law says you have to transfer it within 7 days, but you have not transferred within 7 days. Okay. If you have not transferred within 7 days, you are liable to pay interest. At how much percent? 12%. So company, along with the amount of the dividend, amount of the unclaimed dividend, you will also transfer 12% in the unpaid dividend account. That interest will also go to the investor as per the proportion, proportion of his dividend amount. Okay. Now, also it's an MCQ, it can come in the exam, that within 90 days they have to prepare a statement. Within 90 days they have to prepare a statement containing the name of the investor, the last known address, the unpaid amount, and place it on the website of the company and any other website approved by the government for this. That is IPF ka website. So here to prepare the statement of the name of the investor, the last known address, their unpaid dividend amount, it is 90 days. The money should go to unpaid account within 7 days. If it is a delay, 12% interest is there. The money will be staying in unpaid for 7 years. After 7 years, it will go to IPF. To go to IPF, the days are 30 days. See the diagram what we have written in the notes. Okay, we have written in the notes. Then, if 124 or 125 is contravened, how much is the penalty? Sir, company ka penalty is 1 lakh rupees, 500 rupees per day subject to maximum 10 lakh. So the penalty is how much? 1 lakh, 500 per day subject to maximum 10 lakh. Officer, sir, 25,000 to 2 lakh 100 rupees per day. 25,000 to 2 lakh 100 rupees per day subject to maximum 2 lakh. So penalty it's only for the MCQ. Descriptive में 124, 125 में very rare because they generally ask on rule 3. We'll be doing rule 3 now. Okay. 124 talks about unpaid, 125 talks about IPF, 124 talks about unpaid, 125 talks about IPF. Okay. Then next answer is about IPF. If you remember IPF. Sir, 2 answers we have done from the book. Sir, what are the sources of IPF? We have written a code in the notes. You can check that. Dadi is great. Remember the Dadi is great? D. Sir, D is what? Unpaid dividend. Sir, A. Application money. Outstanding application money. Again D. Unpaid deposits. One more D. Unpaid debentures. I. Interest on above. Sir, unpaid dividend, outstanding application money, unpaid deposits, debentures, interest on above. Is interest on investment from IPF. Interest on investment from IPF. Sir, G. Great. Grants, donation from CGSG, company, financial institution. So they have given more sources also, but we have written this Dadi is great. So they can ask us in MCQ. Out of 4, 3 they will give source, 1 they will give utilization. Okay, odd man out you have to do. Sir, where will the money of IPF will be used? Sir, money of IPF would be used for refund of what? Sir, same point, refund of unclaimed dividends, deposits, debentures and application money and its interest. Number 2, sir, for reimbursement of legal expenses for class action suit. So whatever case you have filed, you will get the reimbursement of that. Third, sir, the name, promotion of investors, education, awareness and protection. My favorite. Number 4, any other purpose, So what they can do is 3 they can give utilization, 1 they can give credits, source of IPF or vice versa. One more is there, distribution of disgorged amount to the eligible applicant. That's basically compensation. Distribution of disgorged amount basically means the compensation to the shareholders, debenture holders, depositors who have suffered any loss. So 5 utilizations are there. Then this also we have done. Any person who is claiming to be entitled to the amount referred in section 125, that's IPF, may apply to whom? Any authority constituted under section 125(5). Who is that authority? Sir, Investor Education Protection Fund Authority. So 1 mark answer. This was also asked, to whom you have to claim the money. You have to claim from Investor Education Protection Fund Authority. Investor Education Protection Fund Authority, AAA Authority. Cool. So then here the chapter was over. We are just left with rule 3. Let me just read rule 3, then we do a question on rule 3. Okay. Rule 3. Sir, what does rule 3 says? Today, if you want to declare dividend, but you do not have a money, or money is there but money is less, either you do not have a profit or profit is there but it is less. Okay. So what you do? You follow rule 3. Rule 3 ka 3 conditions. Rule 3 ka 3 conditions. Rule 3 ka 3 conditions. Condition 1. Sir, my rate of dividend should be less than or equal to average rate of last 3 years. My rate of dividend should be less than or equal to average rate of last 3 years. But this condition should not be checked when no dividend is declared in each of the last 3 years. This condition will not be checked when no dividend is declared in each of the last 3 years. Sir, what does each of the last 3 years means? Year 1 0, year 2 0, year 3 0. Year 1 0 and year 2 0 and year 3 0. Divided by 3, how much you will get? 0. Okay. But sir, if any of the case mate is declared, then you have to check the now condition 1. And whatever amount you withdraw from the reserve, it should be less than or equal to 10% of paid up share capital plus reserve. It should be less than or equal to 10% of paid up share capital plus reserve. Whatever money you have withdrawn, it should be first used to set off current year losses. And third condition, amount in reserve after withdrawal. So balance of reserves after withdrawal should be more than or equal to 15% of paid up share capital. Should be more than or equal to 15% of paid up share capital. So first condition is less than equal to, second condition is less than equal to, third condition will be more than equal to. Okay. So 3 conditions you have to check. When you are declaring final dividend, and your money is not there, or money is there but it is less. So you follow rule 3 conditions. Understood? Let me open a question for you so that you get confidence. We'll do it from a book only. Just give me 1 minute. Rule 3 is applicable to interim dividend. No, rule 3 is for final dividend. So let's quickly calculate. So I am doing it with you so that we save our time. Okay. A company has accumulated free reserves of 75 lakh during the last 5 years. Okay. It has not declared any dividend during this year. That means in last 5 years they have not declared any dividend. Correct? They have not declared. That means my first condition becomes not applicable. Your brain should start processing that way. Okay. Number 2. Now the company proposed to appropriate part of this amount for making payment of dividend for the current year. Now when they say payment of dividend word is used, that means it is always final dividend. Okay. In which it has earned a profit of 20 lakhs. So 20 lakhs becomes current year ka profit. Okay. Now the board proposed a payment of 30 lakhs. So 30 lakhs, that is 30% of the paid up capital. Now I want to pay 30 lakhs. Okay. I want to pay 30 lakhs but I have only 12 lakhs. That means money is there but money is less. Money is there but guys money is less. That is insufficient profit. Okay. Now as per the Companies Act, decide whether the proposal of company is valid or not. So I would say I will follow rule 3. Right. So my first condition not applicable. Second condition. So what is my second condition? And amount withdrawn should be what? Less than or equal to? Should be less than or equal to what? 10% of what? Paid up share capital plus free reserves. And this amount should be used to set off current year losses. But current year there is no loss given in the question. So amount withdrawn. Now how much is the shortfall, sir? So 12 lakh I have, I just need 18 lakh rupees, right? So sir, 18 lakhs should be less than or equal to 10%. So what is my paid up share capital? So they have given that 30% on paid up capital is 30 lakhs. So 30 lakhs is basically 30%. So how much is 100%? Sir, 100 lakhs. Correct? You do cross multiplication. So 100 lakhs plus my free reserves is 75 lakhs. Okay. Sir, my 18 lakhs should be less than or equal to 100 plus 75 will give me 175. 175 ka 10% would be how much? Sir, 17.5 lakhs. Sir, second condition is not fulfilled. 17.5 lakhs, okay, is not fulfilled. That means they can give dividend, but they can't give 18 lakhs. They can give how much? 17.5 lakhs. So I can withdraw how much amount? 17.5 lakhs. Now third condition, and balance of reserves after withdrawal. Balance of reserve. My third condition is what? Sir, balance of reserves should be more than or equal to 15% of paid up share capital. Sir, balance of reserve. My 75 lakh was my total balance. I am withdrawing 17.5. 17.5. 5 gone there. 65 more 7. 57.5. So 57.5 lakh should be more than or equal to, paid up capital was 100 lakhs. It should be more than or equal to 15% of 100 lakhs. That is basically 15 lakhs. So sir, third condition is satisfied. That means how much I can withdraw? Sir, I can withdraw 17.5 lakhs. How much I can withdraw? 17.5 lakh. So they want to give, so can they give 30 lakhs? No sir, they can't give 30 lakh rupees. They can give 17.5 lakh from the free reserves and 12 lakh from the current year. So it is invalid. The proposal of 30 lakhs is invalid because they can give how much? Sir, 17.5 lakh from the free reserve and 12 lakh from the current year. So you write both the answers and you say 30 lakh is wrong. You can't give 30 lakhs. You can give 17.5 plus 12 lakh rupees of the old, of the current year ka profit, that is total 29.5 lakhs. Understood guys? Rule 3. Is rule 3 now clear guys? Rule 3 clear? Entire dividend chapter clear? Let me just scribble sections for you so that you remember quickly. So there were 5 sections. So 123 is basically sources. Sir, 124 is basically your unpaid dividend. 125 is basically IPF. 126 is basically abeyance. And 127 is basically time limit for dividend. Over. 2 chapters over, 1.5 days mein. Understood guys? Are you getting confidence? Is the session fruitful? Because here we are not doing any time pass because it's your exam time. We are just going straight away to the pointers, just recalling all the provisions and doing it very quickly. Okay. So I am not doing any time pass also here. Reason being, in case you want to revise it during the exam time, like before the exam time, that 1.5 days, so that you can just watch it, so that no time pass is there. Okay. So do recommend to your friends. Whoever is not coming live, they can watch it and record it. Also, it is still there on the YouTube ka channel. Okay, it is still there. Okay. And make sure that you clear. Next chapter is charges. Please open the notes of charges. We will do it quickly. So we move on to charges. Tanish, you can skip that penalty. There's a provision that neither company should deposit the amount of dividend if it is less than 100 rupees. If they don't pay within 30 days, it's okay, provided they follow the condition that they have displayed on the notice board and the advertisement is given in a local newspaper. Just remember that provision. Now, so let's quickly recall charges chapter. Let's try to finish this chapter. So if you remember, section number were 77. All right. 77, 78, 79, 80, 81, 82, 83, 84, 85, 86, 87. This was the section. Cool. Now, I'll take the same example. AB Limited was there. HDFC Bank was there. AB Limited has given their bungalow of 1000 crore to the bank, and bank has given, let us assume, 800 crore rupees as a loan for 3 years at 10% interest. And there's a guy called as Reliance Industries who will be called as a buyer. Now, Sagar, you can buy this chart book from Yeshas Ka website. You can go and buy chart book from Yeshas Ka website. Okay. AB Limited is taking loan from HDFC Bank. Bank is giving the money. The bank is, they are taking secure loan because I have given a property. It's called a secure loan. So HDFC Bank is called as a charge holder or a creditor. Which creditor, sir? Secured creditor. AB Limited would be called as a debtor and Reliance would be called as a purchaser. In the entire chapter, you will find only these 3 people, okay, and the one authority, the one apex authority in this chapter is ROC. Remember this, all the section will be applicable towards ROC. In the entire chapter, you will only talk about ROC, only in one section, that is section number 87. Only in one section 87 where we talk about the CG authority. Rest the entire chain where you will always see the ROC, okay, entire chain. Let's talk about first, what is the charge? So charge basically means any interest or a lien created on a POW. POW means a property asset undertaking of the company or both, and it includes a mortgage. This is a definition of charge we have written in the notes. It is basically an interest or a lien created on the POW. POW means property asset undertaking of a company or a both, and it includes a mortgage. Number 2. Then there is something called as fixed charge and floating charge. Fixed charge and floating charge, okay. Now imagine this is a classroom. In classroom there are 7 ACs. AC number 1, 2, 3, 4, 5, 6, 7. Now, I have taken a loan on AC number 1. So, if I have taken a loan on AC number 1, it is a charge. Bank will have a charge over it. So, bank will have a charge not on all the ACs. They will have only on AC number 1. So, it is one particular definite asset. It is called as fixed charge. It is called the what? Fixed charge. Sir, can I sell that AC? No. If I want to sell, I need to take the bank permission because bank has a charge over it. Bank has a charge over it. Can I use that AC? Yeah, I can use it. Okay. Now, floating charge. Floating charge are basically created on raw material, stock in trade, debtors. Okay. An asset which keeps on changing, an asset which keeps on changing, which keeps on floating. Now, imagine if I have taken loan on pencil. So, the pencil which is ready, I have taken loan on that. Pencil which we have manufactured and kept it ready to be sold, we have taken loan on that. Pencils which are in the process of manufacturing, we have taken loan on that. Pencil which will manufacture in the next month, we have taken loan on that. I have not taken loan on one specific pencil. I have taken a loan on the entire pencil, that is my stock. Correct? It is called as floating charge. Sir, can I sell this asset? Yes, sir, definitely you can sell. In fixed charge, can you sell it? No, sir. Without the permission of the charge holder, you can't sell it. But in floating asset, sir, you can sell it. No permission is required. That's the essence of floating charge, right? Now, imagine if I have taken a loan on the pencil and EMI was there. I have defaulted in the EMI. I have not paid that EMI. What will the bank do? Sir, bank will come to you and take the possession of the stock. Because if you are not paying the loan, bank will sell the asset. That is called as what? Crystallization of floating charge. What it is called as? Crystallization of floating charge. The floating charge will stop. So whatever benefits were given to you, it will be taken away. Like for example, raw material, you can use it in your finished goods, in your WIP and finished goods, right? Then if it is a stock, you can sell that stock. So both the rights will be snatched away. You can't use it, you can't sell it. You can't use it, you can't sell it. That is called as crystallization of floating charge. When does it happen? If you default, if the debtor defaults in repaying the loan, okay. So this also we have written in the notes, you can check that. It says crystallization of floating charge occurs when the floating charge turns into a fixed charge, typically due to events like company's breach of term, liquidation or creditor ka enforcement. When will the creditor enforce? Sir, when you are not paying the loan. Then, before crystallization, the floating charge allows the company to use the asset. However, once crystallized, the charge becomes fixed on the company asset as of the crystallization date. This means that assets are no longer available for regular use and can be seized by the creditor to recover the debt. Crystallization happens when conditions such as default, cessation of business or liquidation are met. So this is like crystallization of floating charge. This also we have written a notes as fixed versus floating and crystallization of a charge. Understood? They have not yet asked in the exam. There are chances that they can ask this in the exam. Now, section number 77, registration of a charge. Very simple it is. Okay. You remember 30, 30, 60, 30, 30, 60, 30, 30, 60, same concept here, okay. Now, sir, first duty is of the company to register the charge. It shall be the duty of the company, in my example, AB Limited, creating a charge whether within India or outside India on its property, assets, undertaking, whether tangible or otherwise, that means intangible, whether situated in India or outside India, to register the particulars of charge with the ROC in form number CHG1 within 30 days. In form number CHG1 within 30 days. It will come on the next box, but I hope you remember the provision. So, company ka duty is a property in India, outside India, tangible, intangible, loan in India, outside India, on its POW means property, asset, undertaking, to register the charge from the day they have taken the loan. So, if the company defaults, whose duty it is? It is the duty of the charge holder. So, section number 78, which section guys? Section 78 will talk about the charge holder. I will explain you later, charge holder. Sir, 79, who will do it? Sir, purchaser will do it. A registration of charge where a company purchased some property in whose a charge was already registered. That means Reliance. If AB Limited has taken a loan on the bungalow and that bungalow is purchased by Reliance, so now in the books of ROC, AB and HDFC Bank was there. Now AB ka name would be removed and Reliance ka name would be there. That is purchaser. Section 77 company, 78 charge holder, 79 purchaser. Okay. Now see. So the particulars of charge created, okay, in form number CHG1, that's normal. CHG9, if you remember 9, DEBEN. TURE 9, CHG9, debenture. So for all the assets, CHG1, for debenture, CHG9, together with the copy of instrument creating the charge. So instrument creating the charge means instrument, loan agreement, okay, signed by the company, and the charge holder shall file with the ROC within 30 days of creating the charge along with the prescribed fee. So you have to register the charge within 30 days of creating the charge. Sir, this is also we have done. Verification of instrument of charge. Verification. Sir, if the property is outside India, who will sign it? Common seal or director of the company or CS of the company or authorized office of the charge holder. 4 people or under the hand of some person other than the company who is interested in the mortgage or charge. Basically purchaser. 5 people can sign. I mean out of 5, anybody can sign. Common seal or director or CS or office of the charge holder or purchaser. When the property is in India or partly in India. Partly outside and partly in India, okay. It shall be signed by whom? So, director or CS or officer of the charge holder. Common seal is not there, purchaser is not there. Common seal is not there, purchaser is not there. It is verification of instrument of charge. What it is, guys? Verification of instrument of charge. Cool. Now, sir, all the charge, so this I have cancelled, you know, 2/11/2018. In the main book also we have cancelled it. So, what is the latest provision? It says you have to register the charge within 30 days of the creation. If it is not registered within 30 days, then you will go in within next 30 days along with additional fees, Within this 30 days also it is not registered, then you will register within further period of 60 days along with ad valorem fees, add valorem fees, 30, 30, 60, 30, 30, 60, fees, additional fees, ad valorem fees, additional fees, ad valorem fees, 30, 30, 60, fees, additional fees, ad valorem fees. I hope you remember this. Okay. Now, when you have given to ROC will give you a certificate. ROC will give you a certificate in form number CHG2. ROC guys will give you a certificate in form number what? In form number CHG2. You apply in 1, certificate comes in 2. Then, there's a point in the main book we have done. Section 77 shall not apply to certain charges which are prescribed in consultation with RBI. So, RBI will say, okay, like agricultural land, it should not be registered, is exempted, okay. or maybe like some public property, public garden is there, ground is there, cricket ground is there. No, if you have taken a loan, charge should not be registered. The RBI will exempt it. RBI will exempt it. Okay. That was section 77. Company ka duty to register charge. Company will file an application in form number CHG1 within 30 days. Okay, if 30 days it is not done, then along with fees. 30 days it is not done, then next 30 days along with additional fees. Okay, if it is not done, then next 60 days along with ad valorem fees. 30, 60 fees, additional fees, ad valorem fees. Okay, form number CHG1, debenture is CHG9. Okay, next. Section 78. It says a company creating a charge must be registered. However, the company fails, then who will do it? So the charge holder may apply to the ROC. Charge holder will apply to the ROC. So charge holder means what? HDFC Bank in my example. Okay. And the register shall give notice to the company. Ideally, company ka duty is there to go to ROC. Company is not going. Bank is going it. So ROC will not directly register the charge. ROC will go to the company and say, okay, company, this bank has come to us. This bank has come to us for registration. What is your view? Please tell me what is your view. Now, company replies, objection is received. Company will register, company itself will register the charge. They will say, oh, ROC, we are sorry, we are registering it. The company will itself register, or any sufficient cause is given. Case no, sufficient cause is given. Okay, boss, we to have taken the loan, but we have repaid the loan in 2 days only. So, the charge should not be registered. So, ROC will not allow the registration by charge holder. ROC will not allow the registration by charge holder. Sir, if objection is not received, ROC will register charge within 14 days after giving notice to the company. So you need to reply back within 14 days. If no replies come, boss, what will happen? ROC will register the charge. But the application made by whom? The charge holder, the bank. So the charge holder must have paid fees or additional fees or ad valorem fees, whatever they must have paid. They will pay from the pocket, but they will recover it from the company. This is section number 78. Registration by charge holder. Remember, ROC gives notice 14 days. ROC give notice 14 days. Okay. Then section 79. Sir, 79 basically talks about modification. Now, here it says if Reliance has purchased the property which was already on charge. So Reliance will go to the ROC के पास, delete AB का name and put my name in your register. So it is a duty of the ROC to register that also. It is called as modification, because firstly in the contract 2 people were there, AB Limited and HDFC Bank. Now AB has gone, Reliance have come. So it should be with the Reliance. The name of the Reliance should be registered. So in case of a property where the charge is already registered and if it is sold with the permission of the holder of the charge, it shall be the duty of the company acquiring it, that means Reliance, to get the charge registered under section 77. So purchaser will register it. It is called as modification of charge. Sir, modification basically means what? Any variation. It means any change. So change in loan amount, change in property, change in interest, change in any change is called as modification. So any of the terms and conditions of the agreement, including change in rate, which may be by mutual agreement or by operation of law. So variation in extent or operation of any charge is also kind of modification. Even if the rights of a charge holder are assigned to a third party, it is called as modification. So sir, you will apply in CHG1. For a modification also you will apply in 1. Certificate will come in 3. Certificate of modification will come in CHG3. So for creation 1, certificate will come in 2. Modification apply in 1, certificate will come in 3. So for creation and modification both में the form number is CHG1. 1, 2, 3. 1 may apply, 2 may certificate. Modification of 1 may apply, 3 may certificate. Section 79. Then next we are doing section number 80. In the notes please come section number 80. This we have done a lot of time. Section number 80 guys, section number 80. Sir, what does 80 section mean? Sir, 80 section. Date of notice of charge. Sir, the purchaser will have a date of notice of charge. From which date? Can somebody tell me? From which date he will have the date of notice of charge? The buyer will have a notice of charge guys from which date? Can you tell me? The buyer will have a notice of a charge. The third party will have a notice of charge from which date? Section number 80 we have done in the notes. Very important, very important. Somebody's adding 15, 12, 23. Arey amma yenda kondralo 3 kutrilala ula. That is the example what I must have given in the class. I am talking about the concept. Sir, anyone acquiring an asset with a register charge is considered to have notice of that charge. From which date? From the date of registration. 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 Just remember, from the date of registration. From the date of registration. From the date of registration. Understood? From the date of registration. Section 80 is over. This much only. So rest above katapa. Here also below katapa. Only this much only. From the date of registration. Section number 80. 81. Everybody ka favorite answer? ROC. Register of charges to be kept by ROC. Register of charges to be kept by ROC. Sir, very simple. A register of charges for each company detailing the charges registered should be kept by the ROC. Should be kept by ROC. Sir, who can inspect it? Sir, anybody can inspect. It must be available for public inspection upon payment of prescribed fee. ROC ka register, if you want to inspect, it is section number 81. 81, okay? You have to pay fees. 85. 85 is the brother of 81. Register of the charges. Register of the charges to be kept by the company. Register of charges to be kept by the company. So every company should keep a register of charges, including the verification of the instrument creating a charge at their register office, and it should be available for inspection. 2 people can inspect it for free. 2 people can inspect it for free. Who are the 2 people, sir? Sir, the members and creditors. Who are the 2 people? Members and creditors. That's logical, na? Member, boss, it is your company. You can inspect. Creditor, you have to have given the money only, so it is your right. Okay, but my friend want to inspect the register. Remember inspection? My friend want to inspect. You have to pay the fees. How much fees? Such fees as may be prescribed. With fees or other subject to reasonable restriction in company's articles. So it is free for members or creators, but with fees for other subject to reasonable restriction. Oh, you can watch it only for 2 hours. Okay, after 2 hours you have to come out. Okay. The register of charges preserved permanently. The instrument of charges retained for 8 years after satisfaction. Okay. So the records of charges should be kept for 8 years. The register of charges preserved permanently. Register of charges preserved permanently. The instrument of creating charge is preserved for 8 years. 8 years. Okay. So 81 and 85 both are brother and sister. Register of charges to be kept by company is 85. By ROC it is 81. ROC ka register ke everybody have to pay fees. Company ka register mein member and creator free, others fees. Member creator free, others fees. 81 and 85. 81 and 85. Clear? Then, sir, consequences of non-registration. Sir, what does happen if it is not registered? Obviously, you are liable for penalty. Sir, company AB Limited has taken a loan from HDFC when the charge was not registered by the company, neither by the bank. The bank came for recovery. Aye, bank, you made a boo-boo, you made a boo-boo. We too have not registered the charge. That means it is invalid. So, we will not give you loan. We will not repay your loan. Bank says, Rimaka, come here. Come here, come here. Do you think we are full? Something is written here. Huh? What? Boss, charge is an additional requirement of Companies Act. You have to inform to your mummy. Mummy means ROC. I gave you money, you gave me money. I gave you money, you gave me money only. It says, if a charge isn't registered, it is invalid against the liquidator and creditor, making the charge holder an unsecured creditor. But, hold on, the debt is still valid and enforceable, but the security is lost. The debt is still valid. Sir, the problem is when the company goes into liquidation. When the company goes into liquidation, even if the bank is a secure creditor, you remember this concept, even if the bank is a secure creditor, the bank will become unsecured creditor when the company goes into liquidation. But if the company is not going into liquidation, but they are not paying the money only, saying that boss, charge is not registered, why the hell we should give the money? Boss, you have to give money. Charge is still valid. Loan is still valid. Sorry, loan is still valid. You have to give money. You have to pay the money. Understood? The charge is valid. You still have to give the money. Then 82. So we have done 77. So 77 means company ka duty. 78 charge holder ka duty. 79 purchaser ka duty. 80 date of notice of charge. 81. Sir, 81 means companies register of the charges to be kept by ROC. Sir, 85. 85 8I5 is company ka duty to keep register of charges. Now we are doing 82. Star. Satisfaction of charge. What are we doing, guys? Satisfaction of charge. Sir, what does satisfaction of charge means? Sir, payment basically. Now, company have made the payment, the company will give intimation of payment or satisfaction to the ROC within 30 days in form number CHG4. So, guys, you apply in form number CHG4. Okay, the time limit of 30 days can be extended to 300 days on additional fee. So, 30 ka you can give 300 days. Guys, it is 30 plus 300 or all inclusive 300? Please write in the chat, it is 30 plus 300 or all inclusive 300. So it is all inclusive 300. 30 plus basically it is 270. But in the exam you will remember just 300. Always remember this. Okay. Now you have informed to ROC that we have made the pin. Now what will ROC do? ROC will inform. So ROC will not directly register. ROC will now inform to the bank to show cause him. So ROC shall cause a notice of charge to the charge holder to show cause him in days mentioned in the notice but not exceeding 14 days. So ROC again will give you a 14-day notice. Charge holder, these companies come to us and saying that they have paid the money. You tell me, should I register this or not? Now it says, if no show cause is shown, the ROC shall order the memorandum of satisfaction of charge and will inform to the company, and ROC will issue a certificate in form number CHG5. Will issue in certificate in CHG5. So you apply for satisfaction in 4, you apply in 4, you apply in 4, certificate will come in 5, certificate will come in 5. Okay. So if show cause is shown, they will record in the register of charges, but they will not register it. But if no show cause is shown, ROC will issue a certificate. So it's very simple. All these records are preserved for 8 years. All these records are preserved for 8 years. So it's very simple. Satisfaction ke liye company will go to the ROC. We have made the payment. ROC will go to the charge holder because they have come that they are saying that they have made the payment. You tell me what is the problem. You are not saying me anything. ROC will give 14 days ka time limit. Same. In both the situation, ROC is 14 days. ROC, both the case mein ROC will give 14 days ka notice. Very important MCQ. Okay. Now, if charge holder do not say anything, ROC will register this satisfaction and give a certificate in form number CHG5. Will give a certificate in form number CHG5. Section number is 82. Then 83, you will do it directly. We have written the theory for that. It says power of ROC to register the satisfaction of charge in case of absence of intimation from company. I repeat, it's power of ROC to register the charge in case of absence of intimation from the company. Guys, I just want to test you here. If company is not informing about satisfaction, who will inform to ROC? So it's a direct theory answer. You will do it from the notes. You tell me. If company is not doing it, then who will do it? If company is not doing it, then who will do it? Sir, either the charge holder, if one more guy is there, along with charge holder, the purchaser. Somebody to must have informed them, na? Somebody to will inform them. So it's a direct theory answer. You will do it from the notes. Whatever pointers we have written, that's correct. Okay, you will do it from there. Okay. So either the purchaser will do it or the charge holder will do it. But ROC, you have to register the satisfaction. Certificate will come in 5 only. The procedure is same. Only says whether ROC will register. ROC has to register. They will also apply in 4. Certificate will come in 5. Same form numbers. Okay. So it's power of ROC. So I am saying power of ROC. Then next section number is 84. Oh, receiver, manager of a property. Sir, we say that bank will come and seize a property. Bank will sell the property, but selling will not happen immediately. Boss, selling will take lot of time, right? Selling will take lot of time. In the meantime, they will appoint a receiver or manager. What he will do? See, sir, bank has given money. Bank needs money. So he'll put the property on rent. He will try to sell it. He will put it on rent, put it for exhibition, something else, but he will recover the money. Now it says, if a person obtains an order for the appointment of a receiver or manager, it is basically the charge holder. Charge holder obtains the appointment order for a receiver or manager, or if such person is appointed, they will notify the company and ROC. So the bank will inform the company and ROC, okay, boss, receiver is appointed. This notice should include a copy of the order of instrument and must be submitted within 30 days from the date of order or appointment. So you inform to ROC within 30 days. Now, upon receiving the notice and the prescribed fees, the ROC will register the details of the receiver, manager or the relevant instrument in the register of charges. So ROC will take a note of them. Now, when the appointed receiver manager ceases, sir, when he will cease? When his job is over. What was his job? To recover the money. If the money is recovered, the job is over. Then they must inform the company and the ROC. They will inform the company and the ROC, who will then update the register accordingly. So why will not he inform to charge holder? Boss, charge holder has appointed him, charge holder has got the money. So he has no duty to inform to the charge holder, he will inform to the company and the ROC. In the first point, the bank is informing to the company and ROC that my receiver is appointed. In the last point, the receiver is informing. The receiver is informing to whom? To the company and the ROC. Whether you are appointing him or whether the cessation of appointment is happening, it will happen in form number CHG 6 or 7. 6. Notice of appointment or cessation of appointment of the receiver. Notice of appointment or cessation of appointment of the receiver, CHG 6. 7 is register of charge by the company, register of charges by the company, that is CHG 7. So I generally forget CHG 7, register of charges by company. Understood? So whether you are appointing him or whether the appointment is getting cancelled, you inform to the ROC in CHG 6. 7 is the register of charges. So this is section 84. 85 we have done, register of charge by the company, form number is CHG 7. CHG 7. Section number 86 very important, penalty. Very simple, flat penalty, company का 5 lakh, officer का 50,000. Company का 5 lakh, officer का 50,000. In case of any false, incorrect information or knowingly suppresses any material information to register the charge, penalties of 447. Company का 5 lakh, officer का 50,000. In case of fraud, 447. Sir, company का penalty is 5 lakh, officer का 50,000. In case of false information, 447. Section number is 86. Section number is 86. Perfect. Last answer, section number 87. 87. Sir, what is 87? Sir, in case you want to apply to, if you have forgotten something. Sir, forgotten something basically means omission. So while registration of charge or while registering the modification of charge, if you have forgotten something, that's omission. Or if you have given something but it is wrong, it is called as misstatement. So if you want something which is omitted, or if there is some misstatement and you want to rectify that application, or imagine satisfaction was done, so you need to inform to ROC within 30 days. Extended period 300 days, but your 300 days are also over. You want extension beyond 300 days. If you want to rectify because of omission or misstatement, or if you want extension of satisfaction beyond 300 days, you will apply to CEG. In form number CHG 8. And CEG will pass an order for extension or rectification. So if you want extension or if you want rectification, you need to apply to CG in form number CHG 8. CG will see and they will give approval. Over. Chapter over. Finish. Guys, are you able to recall the provisions? How's the session going, guys? Are you guys enjoying? Are you able to recall the provisions? So we have revised 3 chapters. So the homework for the day would be, after finishing dividend, you will first revise dividend once. Just do the questions of the dividend immediately. Same way, tomorrow morning you will wake up, do charges ka revision and solve questions of the charges. So that if you are having any problem, you can ask me in the class itself. Every day I am coming, so that I want your result to be maximum, provided, see, the efforts have to be win-win. It has to be from the both side, right? So we have to walk together. See, if I am taking one step, you also take one step, because ultimately, see, understand, if you are not putting your efforts, it is waste. It is waste of doing this session also and attending at 9:30 p.m. I'm glad that you guys are coming and watching it. So I want everybody who's watching me in live or recorded session that you clear and share with your other friends also. That if you are unable to come live due to any reason, it's okay, but you watch the recorded session. And I'm using the same examples because you have studied through me, so you can easily recall it. And we just did. I know you have a problem of first in, first out. Correct? Full gajni. But at least we can give a try to that so that we get maximum marks. Understood? So before we wind up, let's quickly recall the sections of charges and the form number. Okay? Quickly. So you say at your house, it's okay. If your parents are saying you're mad, it's okay. I'm mad, you mad, we both mad. But the day we get a result, everybody would be shut. Everybody would be quiet there. Okay? Quickly. Sir, section 77, duty of the company to register charge. 78, banker, that's basically the charge holder. 79, purchaser ka duty. 80, date of notice of charge from the date of registration of charge. 81, register of charges by the ROC. 82, I forget 82. 82, satisfaction. 83, power of ROC to register the charges. Okay. 84, notice of appointment of receiver or manager. Correct? 85 is company ka duty to company's register of charges. 86 is penalty. 87 is rectification. Perfect. Cool. Let's do the form number. CHG1, registration of all the assets, certificate will come in 2. Debenture is 9. Okay. Then for modification apply in CHG1, certificate will come in 3. CHG3. Okay. For modification, for satisfaction apply in 4, certificate will come in 5. CHG6 is basically about the receiver. 7 is about register of the charges by the company. CHG8 is rectification. CHG9 is debenture. So to solve your question book is enough. Yeah, it covers a lot of questions. At least you do that much. Plus, I have released question bank. It is given for free to everybody in the Telegram group. Download it. It covers till Jan 25 all the questions. Whatever questions have come from till Jan 25, MTP, RTP, all are there. It is free. Solve that much at least if you have guts. I to remember everything. What about you guys? Do you guys remember the content? So I am getting a lot of confidence. I do not know about you. I hope you also feel the same. Cool. I think tomorrow we have lined up deposits chapter. So tomorrow we're gonna do deposits chapter, guys. So be prepared with the deposit. In the meantime, please finish off all the questions from the question bank and from the book. And tomorrow we do deposits. Okay. Cool. So 1 hour every day with me, guys. Trust me, law is very easy, very simple. You can easily crack it. You can get 70. Okay. Aim for a rank or 70 plus, whichever is earlier. Cool. We meet tomorrow at 9:30. So do message me in the chat or Instagram, Telegram that how is the session going. See, I'm speaking very fast. Reason being, it's just a revision session so that you concentrate and you use this when you're doing second and third revision and the exam day ka revision. I'm not doing any time pass, no more examples, just recalling the concept. When you're traveling, you can hear it. If you want it little slow, make the speed of the YouTube slow. Automatically the concept will become slow. But don't watch it in 2x. Okay? For detailed content, you have to watch the classes. It's not in detail, it's only for exam oriented. Cool? Bye guys, take care, good night. We meet tomorrow with deposit charge.